Today on Bench Briefs, we're looking at a recent Supreme Court of Canada decision that tackles a tough question about police powers and your rights at home. In R v. Bilodeau, the court had to decide when, if ever, police can enter and search a person's home without a warrant, and what happens to evidence if those rights are violated. Here's the story. Bilodeau was charged with possession of a controlled substance for the purpose of trafficking. The police suspected that illegal drugs were inside his residence. But instead of getting a search warrant, the officers went into Bilodeau's home relying on what's called exigent circumstances. That means they believed there was an urgent situation that justified acting immediately without the usual judicial approval. During the warrantless search, the police found drugs and paraphernalia linked to drug trafficking. Bilodeau challenged the search, saying it violated his rights under the Canadian Charter of Rights and Freedoms. Specifically, he argued that the police didn't have a proper legal reason to enter without a warrant, and so the evidence they found should be excluded from the trial. This raised two big legal questions for the Supreme Court to consider. First, was the warrantless search justified under the exigent circumstances exception? Generally, the law requires police to get a warrant before entering someone's home to protect privacy and prevent arbitrary searches. But there are exceptions. Exigent circumstances can include situations like an immediate threat to safety, risk of evidence being destroyed, or hot pursuit of a suspect. The court had to decide if what the police faced in Bilodeau's case met this high standard. Second, if the search was not justified and therefore violated Bilodeau's charter rights, should the evidence found be excluded. Section 24(2) of the Charter says courts must exclude evidence if admitting it would bring the administration of justice into disrepute. The court had to weigh the seriousness of the rights breach against the importance of the evidence to the case. In its decision, the Supreme Court carefully examined the facts and the law. The court emphasized that the home is a place where Canadians have a high expectation of privacy, and warrantless searches are a serious intrusion. It reiterated that exigent circumstances must be clearly established by the police, showing that waiting to get a warrant would have caused imminent harm or loss of evidence. The court found that in Bilodeau's case, the police did not meet this burden. The circumstances did not justify bypassing the warrant process. As a result, the search was unconstitutional. Turning to Section 24(2), the court decided that excluding the evidence was necessary to uphold the integrity of the justice system and to deter future unlawful searches. So why does this case matter? R v. Bilodeau reinforces the fundamental principle that police must respect charter rights, especially the right to be secure against unreasonable search and seizure in the home. It clarifies the limits of the exigent circumstances exception, ensuring that it cannot be used as a shortcut to bypass judicial oversight without a genuine emergency. This decision protects Canadians' privacy and sets a clear message that evidence obtained through unlawful searches risks being thrown out. For lawyers, police officers, and everyday Canadians, this ruling highlights the importance of balancing effective law enforcement with constitutional rights. It reminds us that the rule of law requires police to follow proper procedures even when investigating serious crimes. And it reassures the public that their charter protections are real and enforceable. Thanks for listening to this episode of Bench Briefs. Join us next time as we explore more important legal decisions shaping Canadian law and society.